pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. All right, I'm going to first take up House Bill 313, and the chair recognizes Representative Perez for a motion.
Thank you. I move to retain this bill.
All right, is there a second? Representative Kutab.
Sorry, which bill is this?
313.
Oh, yes, I second.
All right, Representative Perez, would you like to speak to your motion?
It needs work. The bill needs work, and I think we can tweak it a bit so it might be more palatable. But as it is now, it's not ready for prime time.
All right. Anyone else wish to be heard on House Bill 313? Representative Smith.
I guess I'd just say that left to my druthers, I would have ITL the bill, but I'm always willing to give people a chance to improve the bills that come before us. And so because of that, I would support the retain motion.
All right. Anyone else wish to be heard on House Bill 313? All right. Seeing none, the motion before us is to retain, and I would ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Representative Giuson,
Giason, yes.
Giuson. Representative Tripp,
Yes.
Representative Andrus,
Yes.
Representative Kutab,
Yes.
Representative Perez.
Yes.
Clerk votes yes. Representative McFarland,
Yes.
Representative Guzovsky,
Yes.
Representative Smith,
Yes.
Representative Horrigan,
Yes.
Representative Birch,
Yes.
Representative Harvey,
Yes.
Representative Manos,
Yes.
Representative Tur,
Yes.
Representative Rombo,
Yes.
Representative Bergeron,
Yes.
and Chairman Lynn.
Yes.
18 yeas, 0 nays.
All right. All right. And since that's a retain, we don't need any retain.
Great advantage of retaining bill.
All right. Next, I'm going to turn to HB 391 FN, and I would recognize Representative Smith or her designee for a motion.
Not seeing anyone jumping up. Mr. Chair, I move ITL on 391.
All right, is there a second?
I'll second.
Okay, all right. Hang on. All right, Representative Smith, do you wish to speak to your motion?
I would wish to have Representative Birch as the second speaker.
Representative Birch?
Thank you much for that honor, Representative Smith.
Always look for ways to honor you.
What I can say is about strategic lawsuits against public participation. Some people like them, some don't. They address a specific problem, but they do close the door to courtrooms in some respects. I will, in the interest of full disclosure, indicate that I am a sponsor of a co-sponsor of a different anti-SLAPP bill from Representative Burrows, which I think is a better bill. It's more focused on a specific problem. My belief is that this bill is far too general, and therefore the balance of good and harm shift, and therefore I would recommend ITL.
Anyone else wish to be heard? So the only thing that I would say, I think I generally agree with what Representative Birch said. The thing that I felt when we had this bill, a similar bill last year, and I feel now is, I think it's very unlikely that one of these slap bills actually will produce the increased time to resolution of a case that is claimed, because I think it would be the rare case in which it's not really disputed whether the intent or effect of the lawsuit was to hinder First Amendment rights. My suspicion is, in most cases, there will be a big fight about that. There will have to be discovery, and so it will take as long as it would usually take. The other thing that concerned me about this bill is that there is at least some language in the bill that uses the term prosecution, which could arguably mean that this bill and the so-called expedited manner of disposing of cases could apply to criminal cases. And it's a very general proposition in the criminal law, as I'm sure Representative Birch knows, that there aren't any summary judgment motions in criminal cases. If an indictment is returned, the case goes to trial. So for all those reasons, I share Representative Birch's view. Anyone else wish to be heard on 391? All right, seeing none, I would ask the clerk to call the roll. The motion is ITL.
Vice Chairman Mannion,
Yes.
Representative Giason,
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez. Clerk votes yes. Representative McFarland,
Yes.
Representative Guzovsky,
Yes.
Representative Smith.
Yes.
Representative Horgan,
Yes.
Representative Birch,
Yes.
Representative Harvey,
Yes.
Representative Manos,
Yes.
Representative Tur,
Yes.
Representative Rombo,
Yes.
Representative Bergeron,
Yes.
Chairman Lynn.
Yes.
18 yeas, 0 nays.
Consent? Any reason this can't go on consent? All right, consent. And Representative Smith, can I impose upon you to prepare a report?
Well, you could, but I would impose upon Representative Birch to ask him to.
Representative Birch, would I?
Not if you want it tonight, because I.
No, not tonight. How about tomorrow morning?
Just trying.
Come on, you can take my report from last year and just.
have. All right. I'll do it.
All right, thank you.
Call it a blur.
A blurb, of course, yes. All right. All right. All right. Next, I'm gonna skip over 400 just because one of the reps that, and frankly, I don't remember who, but I got a message that one of the reps who was interested in that would like to be here if possible and can't be here until 2. And what I told the person who gave me that information is I would try. I'm not going to delay our proceedings for this, but if I can accommodate her by doing the other bills first, I would do that, so maybe she can be here to hear what we have to say. So I'm going to skip 400 and go to 462, establishing a cause of action for unwarranted video imaging of residential properties. And the chair recognizes Representative McFarland for a motion.
Thank you, Mr. Chairman. I move ITL.
All right, is there a second? All right, Representative McFarland, would you like to speak to your motion?
I'd be happy to. I think that the bill on its face is an issue which is not something that warrants to be in the law and is one that, if it were in statute, would create some First Amendment issues and some other property rights issues.
All right, anyone else wish to be heard on HB 462? All right, seeing none, I will ask the clerk. Yes, of course. I'm sure. Take your time. We'll wait for you.
Vice Chairman Mannion.
I'm sorry.
Oh,
So,
sorry.
I'm sorry. No, I
Sorry.
just wanted just to repeat. It's on House Bill 462. The motion before us is ITL. So go ahead.
Vice Chairman Mannion.
Yes.
Representative Giason.
Yes.
Representative Tripp.
Yes.
Representative Andrews.
Yes.
Representative Kutab.
Yes.
Representative Perez. Clerk votes yes. Representative McFarland.
Yes.
Representative Guzovsky.
Yes.
Representative Smith. Representative Horgan.
Yes.
Representative Birch.
Yes.
Representative Harvey.
Yes.
Representative Manos.
Yes.
Representative Tur.
Yes.
Representative Rombo.
Yes.
Representative Bergeron.
Yes.
Chairman Lynn.
Yes.
18 yeas, 0 nays.
Consent. Anybody object to it being on consent? All right. Consent. And Representative McFarland, could I ask you to write the report, the blurb?
I'll be happy to. Is that required on consent?
It is. It is required. Yeah.
Just not on retain.
Right. And if you could get it to me by tomorrow morning, I'd appreciate that.
Sometime tonight.
Or sometime tonight is even better.
You already wrote it.
All right, turning to HB 509 FN, the chair recognizes Representative McFarland for a motion.
I move OTP.
Is there a second?
I second that.
All right, motion's been moved and seconded. Representative McFarland, would you like to speak to your motion?
Certainly, in the spirit of keeping things brief, I will say that I think that the information that is requested here is warranted and appropriate and will be useful for further legislation, as we heard from the bill's sponsor, and I heartily recommend the bill.
All right, anyone else wish to be heard on 509? All right, seeing none.
I have, I really want other people to do this, but, I have no problem with providing information. And I think we do a good job of providing information. And I don't remember if it's 4 or 5 items, and I think they're quite reasonable. This list would require a lot of items. It will require spending money, which we don't like to do, to get the details that are required. It doesn't take into account the fact that these are all matters that aren't resolved within 2 or 3 months or 1 year, so that they come up again and again and again. And I think that there are better ways to spend time and money that would give us information that could better inform our decision making than is required under this bill. Thank you.
Anyone else wish to? Yes, Representative Horgan and Representative Turner.
Yes, I mean, they do, the AG does express the opinion that he thinks the feds would pay for the cost of it, but I still think
I'm
it's.
sorry, could you repeat that? I didn't quite hear you.
I'm also opposed to the OTP and the cost. The cost is significant, and the AG seems to think the feds would pay for it, but just given all the chaos in Washington, D.C., I think there's no guarantee that they will pay for it. And even if they will pay for it, I think it's money that doesn't need to be spent, whether it's at the state or federal level. So it's an unnecessary bill. So so that's just one of several reasons why I would not want to vote for it.
All right, Representative Turner.
Yeah, I also agree there's nothing sort of wrong with the content that's being requested, but as I brought up in the hearing, the idea that it's not a unique report of each forfeiture is troubling, because it does sort of feel like the same activity could end up on multiple years of reporting and sort of exaggerate or not allow us to duplicate or unduplicate the forfeitures that are being listed. So I feel like something like it would be good, but this one maybe not.
Anyone else? Representative Birch.
Thank you, Mr. Chair. I also am troubled a bit by it because I don't think it's necessary. We already collect data. We may collect data on 5 points. this will maybe add another 15 points, but I'm not sure the cost to the taxpayers because we have to collect the data as well as collate it, put it out, and distribute it. So there are significant costs, and it may be unnecessary. The idea of collecting it, because maybe at some future use we might want to have it at some future time, but we'll soak the taxpayers now, I think is not the way to go. Thank you.
Anyone else wish to be heard on 509? So I guess the only thing I would say, and I was not at this hearing, but what was my understanding is that no one from the AG's office was here for the hearing, or at least if they were, they didn't say, this is going to be unaffordable. We can't do this. There's going to be a huge problem. And since they are the ones that would have to be in charge of getting this information, that is, I think the fact that they didn't say that is pretty significant. So for those reasons, I intend to support the OTP motion. Yes, Representative Smith.
I could just respond to that. When the AG shows up here, which they do when they have to, they are very clear that they are not taking a position, that it is our job to set the policy, and once the policy is established, they'll do what they're required to do. So the fact that they didn't come and say, that they had problems with this, I don't think is, I think the word would be causative in terms of having us decide. It's rare that we get something from the AG or from any department that says definitively that they support or oppose a bill.
Well, I guess I would say in response, I agree with you to this extent. I think it is true that they rarely take a position, support or oppose, but what they often do, and in fact, the most recent example that comes to mind is the hearing we had last week on HB 195 and 522, where somebody came and said, here are some problems we have with the wording, and you should change this or you should change that. So what I'm saying is, I think what the AG's office will do, even if they don't take a position on the bill, if they see that there's, something is going to cost a lot of money, or there needs to be additional resources or something like that, my experience has been that they usually will say that kind of thing. And again, I was not at the hearing, but my understanding is that they did not say that at the hearing in this case. Representative McFarland.
Thank you, Mr. Chairman. Yeah, I believe you're correct. And on top of that, my recollection of the hearings that transpired that day was that we had a number of law enforcement officials here to speak about not just that bill, but related bills. And the topic of the information around forfeitures came up, and it was clear from the responses that however they may have felt on the bills, they felt that they had the information at their fingertips.
Anyone else? Yes, Representative Manos.
Thank you, Mr. Chair. I would also oppose OTP on this. One of the problems I see is that the bill provides that the Attorney General would report 120 days after the close of the fiscal year. And that might take a case that is proceeding over 2 fiscal years and split the data about one particular case between 2 fiscal years, which seems to me to defeat the purpose of this. It's very possible that one case is going to extend over more than 1 fiscal year, and then you end up with bifurcation of the data. And I don't think from a practical point of view that this works very well.
Right.
Thank you.
Anyone else wish to be heard on 509? All right, seeing none, I would ask the clerk to call the roll. The motion is OTP.
Vice Chairman Mannion,
Yes.
Representative Giason,
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez. Clerk votes yes. Representative McFarland,
Yes.
Representative Guzovsky,
Yes.
Representative Smith. No. Representative Horrigan,
No.
Representative Birch,
No.
Representative Harvey,
No.
Representative Manos,
No.
Representative Tur,
No.
Representative Rombo,
No.
Representative Bergeron,
Yes.
Chairman Lynn.
Yes.
11 yeas, 7 nays.
All right. Representative McFarland, can I call upon you again for the report? And will there be a minority report? No, no minority report. All right. All right. All right, I'd like to next turn to House Bill 520, authorizing hearing officers of the Department of Education to issue subpoenas. And the chair recognizes Representative Kutab for a motion.
Thank you, Chairman Lynn. I move ought to pass.
Is there a second?
I'll second.
All right. The motion's been made and seconded. Representative Kutab, would you like to speak to your motion?
I think we've discussed this bill extensively both last year and this year, and I did go through and I saw that there were multiple other departments which had allowed for their either commissioner, commission, or board to all issue subpoenas, and the DOE commissioner was essentially kind of the only one who didn't have it. There were 10 other commissioners who all have it, including the lottery commissioner, the revenue commissioner, the insurance commissioner, the labor commissioner. It goes DES. The list goes on, and then there's several boards, councils, and commissions, including the Liquor Commission and the Executive Branch Ethics Committee. So I think it's really important that we make sure that our commissioners have the tools that they need to get their job done. Thank you.
Anyone else wish to be heard on HB 520? Representative Tur?
He's got an amendment.
I'm going to amend the bill introduced, but let's let Representative Birch go first.
Representative Birch.
Thank you. I'm opposed to the OTP on this for a host of reasons. Probably, well, I hate to relativate them, but certainly one of the more important reasons is the DOE came in and said, we've been able to get all the information we want already without this in-house expansion of power. So if there isn't a problem, why are we working on a solution? Secondly, we know that the Attorney General has the authority already to do what this bill does. And in essence, this is, I don't know whether it's a power grab or a turf issue or whatever, but it seems as if the Department of Education wants to run the show itself by having its own hearing examiner, its own prosecution, so to speak, of the case, its own subpoena power at the investigatory stage, where the person being investigated has no equivalent power to compel evidence and witnesses for themselves. So it's an unbalanced proceeding. It's an unnecessary proceeding. And for those and probably other reasons, I urge the OTP to be defeated.
Any Representative Smith?
Thank you. I wonder if someone supporting the legislation would help me better understand the connection between the bill and the testimony. The bill says that the subpoena has to do with the violation or possible violation of the educator code of conduct by a certified educator. The code has to do with child safety. It has nothing to do with curriculum. And yet the examples that have been given by people who support this bill all had to do with curriculum. And I think that this is an attempt to either have a sheep in wolf's clothing or a wolf in sheep's clothing. I'm not sure which, but whatever it is, I don't think it is, I don't think that the language of the bill specifically supports the arguments that have been presented to us in favor of the bill.
All right. Anyone else wish to be heard? Yes, Representative Kuto.
I'd like to also mention that every other New England state, they all have this power. And so I really just don't think that it's unreasonable for them to have it. Even in Connecticut, Rhode Island, Maine, Massachusetts, and Vermont. So thank you.
Anyone else wish to be heard? Representative Tur?
I don't know if this would be the appropriate time to offer an amendment.
I think we probably ought to vote first on the OTP and then consider the amendment.
Well,
No.
Or do you what?
Because I think technically speaking, if you were to do that, Mr. Chairman, once the OTP passes, that's it.
It's still, no, okay, all right.
If
No,
there was to be consideration of an amendment, it would
okay,
have to
all right,
be-
no, that's, okay,
It would have to be now.
all right. So, no, that's fine. So Representative Tur, do you, I turn the floor to you. What do you want to do?
did you have a comment before I did?
Would it be okay if I just added a brief additional comment to my comments?
Of course, of course.
Thank you, Mr. Chair. I appreciate the leniency on that. I didn't want to forget the concern I had that there's no protection for student records in this legislation. And I'm concerned also about that this bill would create an ability to subpoena children.
All right,
Thank you.
all right. All right, so Representative Tur.
Yeah, so I'd like to offer amendment 0842H to House Bill 520, and I'll speak to it.
Is there a second for that? All right, so motion is made by Representative Tur and seconded by Representative Manos. Hang on one second. All right, yes, Representative Tur, go ahead.
Yeah, thank you, Mr. Chair. So let me summarize the amendment first, which is basically what it does is it takes the subpoena power as originally written going to the hearing officer and replaces it with the attorney general. We heard in our testimony that that is done by a range of state agencies. The amendment was drafted based on a RSA 170E41 Part 2, which pertains to child daycare, residential care, and child placing agencies. So this is very consistent with the idea of hearings regarding standing, licensure, certification, et cetera, which some of the other agencies that we just heard about don't get involved with. There's a couple of reasons why I'm offering this, building on, I guess, what Representative Birch had mentioned. One, we have heard that there has not been a need for this in the past. So the idea of creating a completely different structure for hearing these, I don't think is really warranted when we can simply allow, and this was the testimony, I believe, by the Department of Education, they're not allowed to approach the AG for a subpoena. If we allowed that, then it could be done through that standard process without setting up another system. The other thing that I think is really almost more important, and I think is a sort of a structural problem with the bill if it doesn't go this way, is the entire process refers back to folks within the DOE, the hearing officers work under the direction of the commissioner of the Department of Education. So the provisions that say that you could make a motion to quash the subpoena or challenge the subpoena, and even the very idea that the subpoena is justified would all be heard by somebody who works under the direction of the person making the subpoena. And I think that's really, I can't see how you get around that within the Department of Education. This, I think, offers us a solution that provides everything that was originally requested. So everything, there would be no, if it was a good faith subpoena request, the AG would have the power to do it, and it would provide all the access that the department needs, but without sort of making it a wholly contained function of the Department of Education. So, and as you'll see, the language of the bill stays largely the same. It just largely replaces the concept of the Attorney General with, or the concept of the hearings officer with the Attorney General. All the other protections and everything that were in the original bill are still in place. So, I don't see this as being radically different in terms of effect from what was proposed, but I think it's radically different in terms of operational implementation and fairness. So I'll stop there.
All right. Anyone else wish to be heard on the amendment? And so I guess what I would say with regard to the amendment is, first, with respect to the issue of, the hearings officer works for the commissioner. I mean, what you raise, Representative Tur, is sort of a fundamental issue that has been litigated by the courts for decades now in the administrative law context. There's always been that argument, well, the hearings officer in this agency or that agency is responsible to the boss of the agency. How can they possibly, that's some kind of a due process violation. They can't be fair. The courts have pretty uniformly rejected that idea in the administrative law context, and there's no reason for treating it differently here. The other thing I would say with, and this maybe goes to both the amendment and the basic bill, is to the extent, Representative Smith, you were saying, there's no need for this. If I recall correctly, even at the last hearing we had on 520, I think that there was some evidence suggesting that there was at least one case in which the department wanted some records, and yes, they eventually got them, but they had to, the school district or administrative unit or whatever wouldn't release them, wouldn't turn them over. They had to go down there and look at them, and they couldn't copy them. It seems to me that that's at least one example of a situation where to me, the fundamental concept is, if you are a regulatory agency and you're entitled to conduct enforcement or disciplinary proceedings, you ought to have the ability to compel someone to provide the information so that they can't say go pound sand in one form or another, whether the go pound sand is we're not giving them to you at all, or you can come down here and look at them, but we're not going to let you copy them. Why? Because the Department of Education we can't trust them? Is that the theory about why they shouldn't be able to look at the records? I'm sorry, I just reject that. So for those reasons, I plan to vote against this proposed amendment, but for the underlying bill. Anyone else wish to be heard?
Can I just clarify?
Yeah.
That I think, again, speaking to the amendment, it's, I don't know if you have any comments. I feel like it still preserves the ability to compel someone. It almost is seems to me to have more weight if it's coming through an attorney general's office than through a hearing officer within the Department of Education.
All right. So I guess the vote first will be on amendment 0842H, whether to adopt that amendment. And since it seems like we have a controversy about it, I'm going to do that by roll call vote. So I would ask the clerk to call the roll on the amendment.
Vice Chairman Mannion.
No.
Representative Giason.
No.
Representative Tripp.
No.
Representative Andrews.
No.
Representative Kutab.
No.
Representative Perez. Clerk votes no. Representative McFarland.
No.
Representative Guzovsky.
No.
Representative Smith. Representative Horrigan.
Yes.
Representative Birch.
Yes.
Representative Harvey.
Yes.
Representative Manos.
Yes.
Representative Turer.
Yes.
Representative Rombo.
Yes.
Representative Bergeron.
No.
Did you hear that?
Was that a no?
I'm sorry, there was a no? Representative Berger?
It was a no.
A no.
No, okay.
And Chairman Lynn.
No.
Seven yeas, 11 nays.
All right, so the motion fails. All right, we're now on to the main motion of ought to pass as is. And so I would again, if anybody want anything else anybody wants to say about the motion on the bill of ought to pass? All right, in light of that, I'd ask the clerk then to please call the roll.
Vice Chairman Mannion.
Yes.
What's this for?
Representative Giason.
Yes.
Representative Tripp.
Yes.
Representative Andrews.
Yes.
Representative Kutab.
Yes.
Representative Perez. Clerk votes yes. Representative McFarland.
Yes.
Representative Guzovsky.
Yes.
Representative Smith. No. Representative Horrigan.
No.
Representative Birch.
No.
Representative Harvey.
No.
Representative Manos.
No.
Representative Turer.
No.
Representative Rombo.
No.
Representative Bergeron.
No.
And Chairman Lynn.
Yes.
10 yeas, 8 nays.
All right. Representative Kutab, can I ask you to write the report? And will there be a minority report?
Yes.
All right, who will,
Representative Tur is volunteering, otherwise I'll go.
all right, majority and Representative Tur, is that okay?
Yes.
All right. Tur.
And that will be, Representative Tur's, the minority report will be OTPA.
Okay, all right. With his amendment. Yeah, that's fine. All right. All right. Next, I'm going to turn to HB 587, FN allowing the admission of one-party consent recordings in certain circumstances. And the chair recognizes Representative McFarland for a motion and perhaps an amendment.
Thank you, Mr. Chairman. Yes, indeed. I move an amendment to HB 587. The amendment should be in front of you, entitled 2025-0843H. This amendment includes the essence of Representative Turer's earlier amendment, as well as a number of other changes that I thought to be warranted, and I'll just clarify them because I see that OLS has not, marked them in bold. They've just kind of replaced the whole language. So the changes that are embodied in this amendment include, as I said, Representative Turer's one that you've already seen, and also in section 1 where it changes and adds the subparagraph N. I have added the words "who is a party to a conversation" or "who has the prior explicit consent of such a party," so that the statute, if passed, would reflect that this is applicable only to parties to the conversation or their agreed designees, and not a third party with no consent, which is the way that it read previously. The next change I've made is I've added the words "intended to be" in subclause 1, and I've added the words "anticipates or" in subclause 2. So those are the changes, and I hope that they are, apart from that party item, that they are self-explanatory.
All right, so yes, Representative Manos. Oh, your mic, yeah, sorry.
I'm sorry. I wanted to just ask for clarification from Representative McFarland. You spoke about your last two changes, and I wasn't able to pick up where they were. You said,
Sure. So in number one, it says is intended to be provided because I think at the time that the recording is made, it could not be provided to the law enforcement agency at that time. I mean, I suppose one could dream up some sort of live streaming scenario, but I think that's unlikely. So the intent seems to be the important aspect there. And then in number two, I think that it is entirely plausible that somebody might seek to record events with the expectation that there's a crime going to occur, but they then might be wrong, and they might simply delete the recording. And I don't think that that should be, creating a crime because they thought something bad was going to happen and then it didn't.
thank you.
Yes, Representative Tur.
Yeah, thank you, Mr. Chair. So I support both Representative McFarland's changes, and I just wanted to clarify the component that and again, ignore the separate amendment that you have in front of you that I had drafted. I wasn't sure if this was going to come or not. So my content is in here, and all I did was add on essentially line 9, and is not publicly disclosed or released by the person or their agent. And the reason I added that, I think that the testimony around this entire piece of law is that it's quite outdated. It's been around for a long time. It predates a lot of the ways in which recordings and such are used in the modern context. And there are no attempts to change the underlying process, but the way it was written, it would essentially say if you've provided it to law enforcement, there were no other restrictions on what you could do with it. And I think for me, the intent was not to open the door to, giving it to law enforcement and then posting it on Facebook or trying to, hear your case in the court of public opinion. So I feel like that exclusion puts it back within the context of why, in this unique situation, single party recording could be allowed.
All right, yes, Representative Manos.
Thank you, Mr. Chair. I think that Representative McFarlane's and Representative Torr's changes are well meant here, but I read line 9 as in the disjunctive with the ors, and so I took this to mean that the recording is not released by the person, and to me that meant, for example, if the victim released the recording to their pastor or to their therapist or to a DV counselor, that that would not be permitted under this amendment, and I have concern about that. Thank you. So
Mr.
I would
Chairman?
oppose the amendment.
Yes, Representative.
So it looked like, Mr. Chairman, you might have been about to speak there, so I defer to you on the interpretation, but I would say that I think the intent is that the word publicly is relevant here.
Right, that would be my interpretation too, is that would not, that kind of disclosure to a counselor or something like that would not be considered a public disclosure.
And just to add on, during the hearing, the word solely came up as a possible way to amend the language, and I specifically didn't go with that to allow for those type of disclosures, but not public disclosure, because solely would have limited that.
Can I just add to that?
Yes, Representative Manning.
So I think I see the confusion. Reading it as publicly disclosed or released rather than publicly disclosed or released, which is I think what the intent is. If that clarifies it. Perhaps.
So, I guess I would say is, I'm sorry, Representative Birch. Go ahead.
Yeah, so I'm kind of puzzled about how both of these sections work, subsections work. So my first question is intended to be provided to a law enforcement agency or utilized in a certain way. That intent presumably does not have to be carried out. It's only an intent. Is that right?
May I respond?
Yes, of course.
So I believe that is correct, Representative Birch. In the example I gave earlier, and I think one of the examples that we've heard from the sponsors that they are focused on in the reason they brought this bill forward centers around domestic violence. And if we contemplate domestic violence hypothesis where there is a pattern of behavior, there is a recording that is set to take place of what is expected to be a continuation of that pattern, and then that continuation does not occur in that instance, well, there would be nothing in that recording that would be warranting providing it to a law enforcement agency or so forth. So I think that's where I'm going with it, but maybe I'm misinterpreting your question.
All right, to go further, because still puzzled on that, who is encompassed, this is a bit from Representative Manos, by or their agent. So if a, just going to use gender wrong language, if a guy's calling up his ex and the ex records the conversation and believes there's something bad on it of this nature, and they turn it over to the coalition. Coalition is considered their agent.
Sorry, who's the coalition?
Oh, the New Hampshire Coalition Against Domestic and Sexual Violence.
Yes, okay.
Are they now an agent of the purported victim, or are they an independent?
Yeah, I mean, I think
group?
my response to that would be that I'm not going to speak for the underlying bill and for the purpose of the underlying bill. I merely saw this as a change that improved the language of the bill. Now, you may have your own opinion as to whether the bill is warranted and whether it's appropriate to talk to council, talk to the coalition.
You didn't
on
add
whatever.
the language or their
That's
agent?
Representative Torres'
That's my
language.
that's
Oh,
what
that's
I was going to
yours.
say.
Well,
That's my
okay.
language, so I can answer that a little bit. The intent, and you may or may not disagree that it captures it, but I tried to be very specific about the way this was worded. By saying their agent, it meant that they are not giving it to someone else for the purpose of public disclosure. So if they gave it to, their counsel, and, if they didn't intend through their aid directly or through their agent to have it publicly released, there's, once something's out in the world, it's hard to limit what's going to happen to it. I think to the extent possible, hopefully the intent in the language makes it clear this should not be publicly released, but without sort of limiting what the person who made the recording can do with it to further their court case, but still making it clear that they can't release it and they can't authorize someone else to release it was the intent.
Could I just clarify the agent question a little? If because I'm not talking about an attorney who has obligations to keep things confidential that between her and her client, unless otherwise agreed. I'm talking turning it over to an agency such as the coalition. Would that run afoul of this amendment?
Wouldn't it depend on the circumstance? In other words, if it would seem to me that might be something that would depend on the particular circumstances of the case. I don't know exactly how the coalition operates, but if they were providing, if they were going to be the agent, some kind of a counselor, is sort of similar, maybe not in terms of providing legal expertise, but in terms of their obligations to the client, similar to a lawyer, then I would say that they probably would be an agent if for example, the person who made the recording understood that the council was going to issue a press release based on this recording once they got it, then I would say that if the person turned it over to the coalition, they would be violating this provision. So that's what, I mean, I read the word agent to mean you're somebody that's acting in the interest of the person who turned it over.
But okay. If I could just follow up on the word anticipates, because I think we've covered
Sure.
agent enough. I don't know who to direct the question. All right. So I am a, yeah. So I am a putative victim of domestic assault. The other person has a history of calling me, and on some calls is abusive and some calls not. And I pick up my phone and that name is there. Under this amendment, there really isn't any reason to bar me from tape recording every one of the messages from that person. Is that right? Or calls?
So I'll answer that in two parts. I think first of all, the notion that there can be something which would rise to the level of law enforcement action on a phone call. Maybe I'm not familiar enough with the law, but that seems to me absurd in the example you're raising, and I would not be expecting this to be used to claim abuse over a phone call. I would expect, however, that if you had given me a similar example in person in a room where there's a history of somebody beating their partner, let's say, and that doesn't happen on that one occasion. Now you say to me, well, does that give you a right to be recording on a continuous basis? I think the question at hand is what is done with the recording, and whether what is done with the recording meets the letter of the statute as it would exist with this in place. And so it comes back to the question of how you're using it. I think if you look at the RSA 570A, right, there's a whole bunch of exceptions in there, of which this would just become another exception.
All right. Anyone else have anything further to say on this? So I guess I think, personally, I think this is an important bill because it offers the protections that Representative McFarland and Representative Tur pointed out. I think it seems to me that the wording is appropriate. Could there be circumstances where a court would have to construe it? Sure. But I think it sounds to me to be pretty clear language. The other thing I would point out, and Representative McFarland pointed this out to me last night at our caucus on a number of bills, and it was really an excellent catch because I think probably in relying on the title of the bill, which talks about one-party consent, I had been assuming that this amendment dealt with one-party consent, but as he quite properly pointed out, it didn't have that language in it, and so if we had passed it without that provision, I mean, at least arguably, it would have allowed any non-law enforcement officer to, in effect, conduct a wiretap where nobody was consenting and this person was just recording conversations. So I think it was a very good catch, Representative McFarland. In sum, I think this is a good bill, and I intend to support the OTPA with Representative McFarland's amendment. Anyone else have anything they want to say? Yes, sir.
So I just wanted to touch real quick. Somebody had mentioned therapists, chaplains, vet reps, etc. Those people are already sworn to privacy unless there is reasonable, very reasonable need to turn it over to law enforcement only. And violating that privacy is covered under law and under social contract and under medical contract and under a clergy contract. So talking to an entrusted person in that capacity is already protected under law, and that's not a risk in this bill.
All right. Anyone else have any comment? So I may be wrong, but it sounded to me like there was generally a consensus on the amendment. So does anybody object if we vote on the amendment by a show of hands? If anybody does, I'll do it by roll call. All right. So then on amendment 0843H, can I ask all those who are in favor of the amendment, please raise your hand. So. All right, 16, and those opposed, please raise your hand. All right, 16-2 on the amendment. All right, then on the bill as amended, so it would be OTPA on 587 with amendment 0843H. Anybody else want to have any comment they want to make? Seeing none, I would ask the clerk then to call the roll on the OTPA amendment on House Bill 587.
Vice Chairman Mannion,
Yes.
Representative Giason,
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez. Clerk votes yes. Representative McFarland,
Yes.
Representative Guzovsky,
Yes.
Representative Smith, Representative Horrigan,
No.
Representative Birch,
No.
Representative Harvey,
Yes.
Representative Manos,
No.
Representative Tur,
Yes.
Representative Rambo,
No.
Representative Bergeron,
Yes. Yes.
and Chairman Lynn.
Yes.
13 yeas, 5 nays.
All right. Representative McFarland, can I call on you again for the majority report? And will there be a minority report?
There will be, but I want to see if somebody other than me on those 5 votes will do it. Otherwise, I will.
Representative Smith, do you have any view on who should write the minority?
Nobody could do it better than
Representative Birch?
Might be out of my plate,
We-
I agree.
All right. Representative Birch for the minority. All right. Marlon
What?
Birch.
I know, I feel the wheels going over me.
All right. Sure. It's is there somebody here that was interested in House Bill 400? You are the one. Okay, you are the person that was in. All right. So I'm going to turn. We'll take up House Bill 400. And hang on one second. The chair recognizes Representative Smith or her designee.
I guess I can't designate Representative Birch. Mr. Chair, I move ITL.
All right. Is there a second? I'll second. I'm sorry. Who's second? Representative Tur. Okay. All right. Representative Smith, would you like to speak to your motion?
The way people get to yes, the way they reach a compromise, the way they balance competing demands, has a mix of both private and public responsibilities when we're dealing with a public body. I believe that we can end up with a much better result if we recognize that certain parties in negotiations can negotiate among themselves in a more effective way privately. And each of the groups, of course, can negotiate among itself as they try to reach a resolution. I don't believe that the public interest is really gained by adoption of this particular legislation.
Anyone else? Representative Horgan.
Well, yes, so this applies only to the management side of the labor contracts because a union
a union local is not a government body, and so they're, they appropriately would have their discussions about the contract with themselves, and it's probably a bad idea to force the negotiating committee on the other side and the government side of it to be unable to negotiate in private because talk amongst themselves in private because because I think what we want to do is get to yes and reach a consensus about a contract which both sides like, and so the management side would be impeded in getting to a contract which which their counterparts on the union side would like. And I think there seems to be a feeling somehow that if we did this, the public management negotiations would be really, really tough. They wouldn't make any concessions, and that's not necessarily a good thing that they're being really, really tough. And I don't even know if that would be the case. They might actually, most cases, the public is probably pretty sympathetic to the public workers who are trying to get a contract, so they might actually be easier on it. But anyway, it's easier for them. Easier both sides should be have the same, be able to negotiate, have the same rights to speak amongst themselves before they agree to anything. And also, of course, this could in any case be circumvented by bringing a third party. So if you hired some lawyers that would negotiate on your behalf, they wouldn't be a public body, so they would be able to discuss it. But that just kind of complicates the decision-making process. I've probably gone on too long, but anyway, this is not a good bill, and we've killed it before, and we should kill it again this year. Thanks.
Anyone else wish to be heard on HB 400? Yes, Representative Tripp.
I agree with Representative Horgan.
Anyone else wish to be heard? So I guess what I would say is I have mixed feelings about this. On the one hand, I sort of agree with the idea that why shouldn't this be public, but I'm concerned about the unintended consequences and the implications of what a negotiation in public could end up looking like, and would there be, would these become sort of political events where the troops, so to speak, from both sides show up to the negotiations? So on balance, I will support the ITL motion. Anyone else have anything they wish to say? Yes, Representative Perez.
Thank you. I understand what you're saying, but I think both sides at this point are so concerned about their taxes and what their money is being spent on that everyone has a right to the transparency of different things that are being negotiated.
All right. Representative Andrus and then Representative Manuel.
Thank you, Mr. Chair. I understand both sides of the equation, but something has to, and I will vote to ITL, but something has to change. Last week, I went to a school meeting. One of the warrant articles was for the negotiation of staff wages, but none of us know what's in that contract until after the fact. And I think it's sad that I think they could have negotiations on Zoom. I mean, you don't have to let the public, be in, interact with it, but they could know what's going on. Thank you.
All right. Representative Manuel.
Yeah. To answer those questions, the only thing that the town is voting on is the money being allocated, and you have an opportunity during deliberative session or town meeting to do just that. The inner workings of the contract, vacation days, grievance procedures, promotion procedures, to have that be public and open it would be impossible to negotiate a contract that way. Your opportunity to speak on the money being allocated is there. It's during your deliberative session or your town meeting. So, thank you.
All right. Anyone else wish to be heard on HB 400? Seeing none? Well, I'm sorry. Yes.
So having sat on both sides of the table when contracts were negotiated, I have found that you actually are able to achieve a better contract for your town when you don't have all of the noise of the people who are listening in around you. You actually are able to accomplish more for your constituents when you can bargain in a calm and respectful and way that keeps the wishes of your constituents in the front of your head as you're bargaining.
All right. Anyone else wish to be heard on HB 400? All right, seeing none, so I would ask the clerk to call the roll. On HB 400, the motion on the floor is ITL.
Vice Chairman Mannion,
Yes.
Representative Geisen,
No.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez. Clerk votes yes. Representative McFarland,
No.
Representative Guzovsky,
No.
Representative Smith, Representative Horrigan,
Yes.
Representative Birch,
Yes.
Representative Harvey,
Yes.
Representative Manos,
Yes.
Representative Tur,
Yes.
Representative Rombo,
Yes.
Representative Bergeron,
No.
Chairman Lynn.
Yes.
13 yeas, 5 nays.
Representative Smith? Yeah. You have the pleasure. And will there be a minority report? Not seeing any? All right, no minority report. Oh, okay, all right. All right, hang on. All right, Representative Perez will write the minority report. All right. All right.
I have a question. If I
Yeah.
wanted to, if I ever wanted to, like, if I all of a sudden saw a sentence that would make me want to change my vote, how do I go about doing that?
I think if you want to change your vote, on this, are you talking about on the last vote we just took?
Yes,
If
exactly.
you want to change your vote, I'd say now is the time to do it. Either do it now or forever hold your peace.
No.
Do you want to change your vote?
I did.
All right.
Well, then you have to.
So would you like to change your vote? All right. I'm going to allow that. So what do I think your vote was against the ITL motion. So do you wish to change that? So you now wish to vote in favor of the ITL motion. All right. So the vote then changes from 13 to 5 to 14 to 4. Is that correct?
Yes.
All right. All right. All right. That's fine. All right. So we still have Representative Smith will write the majority report. Representative Perez will write the minority report. All right.
Mr. Chair.
Yes.
If I could just make one comment. One of the things that works very well in this committee is that we try to accommodate individuals. To be consistent in this, if you want to change your vote, you really have to be paying attention because it should be before the vote is announced. Once the vote is announced, now you can go back, but it works more smoothly if,
No,
that you just ask, is everybody okay with their votes or something like that? And then you announce the vote.
No, I hear you, and I think you're right. I try to accommodate people when I
For
can.
which we are very appreciative.
All right. 601. I think we are now up to 601, relative to causes of action against companies that misstate the environmental impacts of their business. The chair recognizes Representative Tripp for a motion.
I move ITL.
All right, is there a second? I'll second. Representative Tripp, do you wish to speak to your motion?
Yes, I do. When Representative Reed introduced the bill, I was a little surprised, and she said that, well, this is the first time around, so I'm really looking to get some feel of what the committee thinks, and that and that she would be more than willing to work with the committee to make any changes. Well, the hearing proceeded, and nobody asked any questions. I think the only person asked any questions was Representative Turr, and that was the only question. So if she was intending to improve the bill by working with the committee, that was an abject failure. I do believe that I agree with Representative Reed and that the bill needs a lot of work. It's just it's full of exemptions for someone that wants to be against climate change or whatever. But anyhow, the bill introduces it consists of two things. One is I would consider it falsehoods in advertising, and I believe that is a very subjective thought, because if I was an advertising person, I'm sure I would stretch the truth, but not make it, false. But that would probably give someone that's looking to get after the fossil fuel companies, ammunition. And but another item that I think is a poor choice is that anyone wishing to bring an action against either the untruthful, deceptive, or misleading environmental marketing, or untruthful, deceptive, or misleading net zero claims, is that the person bringing the action doesn't have to have suffered any ascertainable loss because of the either the marketing claim or the net zero claim. I think that would be that'd be a bad idea, and that this would be very tempting for lawyers to keep these companies busy.
Are you saying that this could be the Lawyers Full Employment Act? Is that?
Well, there are some words that could be changed here. But the one that I really like is in the right of action for harms connected to climate change, is in the major disaster meaning, they include tidal waves, tsunamis, earthquakes, and volcanic eruptions. Now, I have a hard time believing that fossil fuels are causing these problems. And that's why I believe that the bill should be ITL'd and sent back for further work.
All right. Anyone else wish to be heard on House Bill HB 601 FF? All right. Seeing none, the motion before us is ITL on House Bill 601, and I would ask the clerk to call the roll.
Vice Chairman Mannion,
Yes.
Representative Geisen,
Yes.
Representative Tripp,
Yes.
Representative Andrews,
Yes.
Representative Kutab,
Yes.
Representative Perez. Clerk votes yes. Representative McFarland,
Yes.
Representative Guzovsky,
Yes.
Representative Smith? Yes. Representative Horrigan?
Yes.
Representative Birch?
Yes.
Representative Harvey?
Yes.
Representative Manos?
Yes.
Representative Tur?
Yes.
Representative Rombo?
Yes.
Representative Bergeron?
Yes.
Chairman Lynn?
Yes.
18 yeas, 0 nays.
All right, any reason it can't go on consent? All right, consent. And Representative Tripp, could I ask you to prepare the report?
Of course.
Thank you. Want to see volcanoes. All right, I think we're up to the last one on our list, House Bill 614 FN, and the chair recognizes Representative Birch for a motion.
Thank you, Mr. Chair. I would move ITL.
All right, I will second the motion. Representative Birch, do you wish to speak to your motion?
Thank you, Mr. Chair. There's a number of difficulties in this bill. One, there's no limit on what are considered nominal damages that the court could award. I mean, normally it's $1, it could be $5, but here it could be any unlimited amount. There's no uniformity of application. The bill makes no difference between an intentional violation and a non-intentional violation. There's no requirement of malicious or recklessness, which is a federal standard for punitive damages. And in essence, this bill could easily shift nominal damages to punitive damages, but not call it punitive damages. We're talking about cases even when the aggrieved citizen says there's no monetary damages at all. And the odd situation where, let's say there's a search and seizure and it's determined to be lawful, it's determined to be unlawful based on a new interpretation of the law by the court. But the officer felt that he or she was doing fine under a prior, in effect, application of the law. My reading is damages could still be awarded. There's a lot of problems here. Thank you.
Anyone else wish to be heard on this? I guess the only thing I would say is I agree completely with what the points that Representative Birch has made. The only other thing that I would say is I think that there is a real question of the need for allowing under state law a right of action to allege a constitutional violation, because I'm not saying absolutely everything, but the vast majority of things that could be characterized as a constitutional violation under state law probably constitutes some kind of common law tort, whether it's defamation or invasion of privacy or assault or battery or false imprisonment or whatever. I think almost all of them would, almost all of the things that could be characterized as a constitutional violation would meet one of those things. Maybe there are a few that wouldn't, but for the reasons that Representative Birch says, I think that there's no reason to have this bill. So I would definitely support the ITL. Anyone else wish to be heard? All right, I think, I'm sorry. Oh, yes, Representative McFarland.
Thank you, Mr. Chairman. So I think that we have heard opinions that there are reasons for this bill. And I guess, some of the examples that have been presented to me resonated strongly with me as being real world examples that I see just, in my own district and in my own conversations. And for example, I was having a conversation just in the last couple of months around a student who was being disciplined for things that she had said outside of the school, outside of the academic environment. And I think that you may be able to come up with some other avenues that would be available there. I'm not sure that I can come up with them, but I do think that this is an appropriate avenue to put in place.
Anyone else wish to be heard? I guess what I would say on that, in response to that, Representative McFarland, is, again, without knowing exactly what the circumstances, it would seem to me that that would very if what somebody said was used as the basis of disciplinary action, it would seem to me that that would at least arguably be the basis of some kind of defamation, that you said something that was the basis for us taking disciplinary action against you. So that can I say that for sure? No, but I think it likely would fall within that. So anyway, that's my response. Anyone else wish to be heard? All right, so the motion before us is ITL on House Bill 614, and I would ask the clerk to please call the roll.
Vice Chairman Mannion,
Yes.
Representative Geisen,
Yes.
Representative Tripp,
Yes.
Representative Andrews,
No.
Representative Kutab,
No.
Representative Perez. Clerk votes yes. Representative McFarland,
No.
Representative Guzovsky,
Yes.
Representative Smith, Representative Horrigan,
Yes.
Representative Birch,
Yes.
Representative Harvey,
Yes.
Representative Manos,
Yes.
Representative Tur,
ITL, yes.
Representative,
No, you got it right.
Well,
I think.
don't ask me, Representative Rombo,
Yes.
Representative Bergeron,
Yes.
and Chairman Lynn.
Yes.
14 yeas, 4 nays.
No, not with 4 votes against it. I don't think we can do it.
Yes, I'll do the blues.
Thank you, Representative Birch, for the majority. Is there going to be a minority report?
There will. Apparently, my evening is not busy enough.
All right. Thank you, Representative McFarland. Minority. All right. I think we are done. And that actually is a lot quicker than I thought it was going to be. So you know what? I want to, the one thing, no. That's a good point. So, you know what, 2 things to take up. One is next week, the 19th, we are, I am likely, and Representative Tripp, I apologize because I know you asked me what if we were going to have something next week, and I think I said no, and I wasn't thinking of this. Next week, we are trying to arrange to have the legislative budget assistant and someone from the AG's office and maybe the Human Rights Commission here to have for a hearing on the audit, the performance audit report. I haven't heard back yet to. Okay, you know what? I'm sorry, they are available? Okay, all right. So I'm hopefully then we'll be able to do that. The other thing, and I hope I have that material with me. I think I do, but I'm not positive. I wanted to spend a minute, if I could, to talk about the information I sent out. We got this letter from Representative Weiler about the budget. Can you give me, excuse me for just a second while I think I have it in the other room. I just want to get that. Could you bring 20 copies?
Where else are they gonna go? So much excitement in here, man.
So, I wonder if we could just take a minute to kind of go through. So the first, taking them in order, the first item that Representative Weiler and the Finance Committee seem to raise a question about is the Board of Tax and Land Appeals. And it appears that there's a suggestion that they want to remove,
This is not, this is these come from, this is
Oh.
from House Bill 2.
right, okay, so, I'm sorry, I was under the impression that this came from,
I hadn't sent it to you, but it comes from House
Oh.
Bill 2.
okay, right,
Which was presented to them
by the governor, oh, okay. They propose apparently to eliminate the requirement that the board have an appraiser and that the board have a clerk.
and you don't
That-
see how they can do their work
It
without
would be, especially the clerk. It seemed like that might be a problem, not having a clerk. I mean, that my view would be to say, I'm very sensitive to the budget, and I have to say that I think getting an appropriate budget, it would be, in my personal view, the most important priority. But to the extent there are choices to be made, I would say, at least for the clerk, that's not a good idea, and probably for an appraiser, since that's a large part of what the BTLA does. Anybody?
And they're not required to be appraisers in order to be on the board.
No, that's true. That's Yes, Representative McFarland.
So I would say two things. The first is that I do not read the changes as indicating that they shall not have a clerk. I just read it that they're taking out the requirement to have a clerk appointed by the board as a classified state employee. It does say the board shall have such clerical staff as may be necessary and may employ such other staff as it shall deem necessary. The other aspect of it, though, with regard to the appraiser, I think if it were as simple as that we were getting rid of the appraiser, then my view would be that the lack of the appraiser is maybe worse than the lack of, more troublesome than the lack of the clerk. But I think, to be honest, in that case, the same holds true. It talks about having such technical staff as may be necessary and employing such other staff as it shall deem necessary. So I'm not sure that these two sentences that are struck there really indicate that they cannot bring on, whether it's on a consulting basis or on some other basis, the skill sets that they need.
You may be right. I mean, I guess my inclination would be that I will say to Representative Weiler, look, we have concerns if the result of these changes would be that there's no appraiser or no clerk for the board. If the language permits the board to continue to do those things, that mitigates it. But those are our concerns. Representative Perez.
I think they're giving themselves the opportunity to have these positions in an as-needed basis. For example, if they do not feel for a particular case they need an appraiser and might be able to use an appraiser an appraisal that was already came from a town or whatever, then they don't need it. If they feel that they don't need a clerk and they can take notes and go from there on their own, it gives them the option of not making of a cost-effective government. How's that?
So I don't disagree with that. I'm a little skeptical about not having a clerk just for an adjudicate, but you may be right. I'm not saying you're wrong. All right. The next one is. I'm sorry, Representative Manos.
Excuse me, Mr. Chair, are you going through paragraph by paragraph? I wanted to comment on RSA 498A:16.
Oh, sure, yes.
May I comment?
Yeah, of course.
This is the bill, we just worked on this bill, I think it was 2 weeks ago, and we made changes to this. I'm not quite sure how the crossed out language, affects the budget, decreases the budget or maintains the budget. I can't imagine that the Board of Tax and Land Appeals is being charged to use county courthouses. And we changed the statute so that the parties, if they can't meet at the county courthouse, if one of them requests that then they meet at the board's office in Concord. So I'm confused as to how this would be a budgetary
I think
savings.
my impression is that this was, the language in what we have before us was obviously before there was the change that we made. I think in some sense, I would assume that to the extent that it says that the hearing shall be held in the county in which the declaration is filed unless the parties agree. To the extent they're taking that out, I assume if it's a money saving intent, the idea would be that the board would be able to sort of compel people not to be in the county if it would save money. Our bill doesn't say that, and who I don't know what finance would do with that ultimately. Yes.
Well, I don't know either, but it is one of their options to incorporate our bill into HB2. And also, if we pass HB2 with this language and our other bill with our other language, they both go to the Senate, and the Senate might incorporate our change into its version of the HB2, although, we don't really want to count on them to do anything, but
Yeah, no, I hear. So I guess the way I understand this process, I thought it was appropriate to get input from everybody here, and I will try to, convey that to Chair Weiler. Obviously, I'm not on the finance committee, so finance is going to kind of do, at least in terms of what they recommend, they're going to do what they're going to do, and I will try to express our concerns on some of these things.
Give them the language of the bill.
Sure, right.
Well, both you and Reverend Smith are alumni of the Finance Committee, though. So.
That's true. She is far more experienced in finance. I just spent one term there. That's that was enough. Yeah. On the next item is appears to deal with removing the director of charitable trusts from the provision, let me see. Yeah, from the provision prohibiting the private practice of law, if I'm reading this correctly. So the provisions of this section shall not apply to the director. So that the director of charitable trusts would be covered by the provision of not practicing law. To me, this is an issue for the AG's office. That's where the charitable trust is located. I would basically say that's not. What does the AG say about this? And let the AG deal with it. The next one is, if I'm understanding correctly from Representative Weiler's markings on this, it deals with the this would add language that would allow the Judicial Council to not have to produce records that are under seal, held by the executive. It's listed under Judicial Council, records held by the executive branch that are not under seal. To the extent I'm understanding this, or confidential in a court file, again, Representative Smith, as the newest member of the Judicial Council.
I have spoken with the, whatever the title is, head of the Judicial Council, who,
Executive Director. I think.
Executive Director, thank you. I knew it wasn't a commissioner, I just couldn't remember. Who is quite comfortable, particularly comfortable with these because apparently he wrote them.
Oh, okay. All right.
Just have to look at the change of cost. Is that coming with slides? Does it make more sense if this is with the
I don't see. This is what he sent me.
Yeah.
It's like this. Seems like it's this.
This one like final terminations.
No. I don't, that may be, you know what, that may be language that the governor's office sent of some, proposed change, but I don't think it applies to us, right? Yeah,
Yeah, so then you go on to the Judicial Council
right,
section.
right, yeah.
Yeah.
The next one is, dealing with compensation of counsel. I'm on now on page 50, what's labeled at the bottom, 57 of 77.
And that's the Judicial Council.
Right, any invoice. Yeah, so this,
And there's, of course, as we all know, they're struggling. I mean, there are three
Right.
ways that we get appropriate legal counsel, and they have no choice but to provide that legal counsel, and they get billed for it, and some of the costs are lower than other costs, and they're just trying to stretch that dollar.
yeah, I mean, I guess, I know, Representative Smith, that probably just before you were appointed, I know that the Judicial Council did propose to the Supreme Court to make some changes, I think both in, well, I think it was mostly the rules, but basically to say that within a certain limit, the judge could just approve certain expenditures, which seemed to me at the time to make sense. Now, I guess my take on this is, I don't think what is anything that's in here really addresses the issue of what are they going to fund, how are they going to fund the Judicial Council? If whether there's going to be more or less funding
That's in House Bill 1.
is an issue, but this, I don't know that it matters that much depending on what the funding is.
But they seem to think it would ease the way, it would be the appropriate way for them to continue, I guess, is what I don't
Yeah.
want to use the word ease because I don't think any of it's ease.
Right. I mean, I suppose in some sense, maybe the thinking is that I'm not sure how much this would save, but if you don't have to go through the process of having the Judicial Council send it to the judge, have the judge sign off on something which is just sort of extra paperwork, maybe that saves a little money. I'm skeptical, but maybe. All right. And then, I'm sorry, there was, you know what, I think I skipped over one thing that I think is actually pretty important. There is, you'll see on page 51 of 77, there, with regard to children in dependency proceedings, there is a proposal to extend the dates in which the appointment of counsel for children is, for lack of a better term, is sort of fully implemented. And let me, I asked for the copy of the original bill from 2024 that is referenced there. Hang on one second. No, they're pushing out the time within which the statute requiring counsel in certain cases, in dependency cases, takes effect. And I think in other words, the idea is to save money. They want to push it out for a couple of years to save some money.
Was this the CFL bill on court appointed counsel for kids?
It's the bill. It's Senate Bill 463 from 2024, which became 2024 laws chapter 296, section 6. And what section 6 says is that the effective dates of, hang on, where is it? This is this paragraph. Right, the effective date that the changes made by that law to the requirement to appoint counsel to represent the expressed interest of a child would be pushed out. Under the original bill, it became effective on August 1, 2026. Excuse me. This proposal, I guess, from the governor would extend it by 2 years to 2028. Yes.
I really think that this should go over to the CFL committee to look at, because this bill underwent extensive revisions and whatnot, and it has a lot to do with the children who were outplaced out of state. I don't know if you guys remember, but over at the Bledsoe Center, who were really undergoing some really abusive situations. And we need to make sure that stuff like that doesn't happen. I mean, they were in a rat-infested home being really abused. So I really think that the members who worked on this might be better able to kind of speak to it. I get that it is a costly item, but I think where they were the ones who heard it and worked on it, we should really defer back to them.
Yeah. No, I will raise this with Chair Pearson and say, maybe you ought to talk to Chair Weiler about this. All right. I think that's it. All right. Anything else?
You did have two things to say.
Can I just?
Yes, of course, Representative.
I just wanted to say that for those of you who are asking about this document that we're referencing, Chairman Lynn emailed it to us on March 2nd and to all the committee members.
I'm sorry. What did I send to everybody?
This packet here.
You sent this packet.
Oh, this packet. Yeah. No, I did send it out. Right. Okay. So the other thing, the chair recognizes Maya.
Talk. Go ahead.
Have a nice day.
Oh, well, you too, and thank you so much, Maya, for you were excellent during our meeting, for sure.
Almost as shy.
Better than exactly. What was I going to say? The reports by tomorrow morning, if I could, please. We'll have hearing on our last two bills on Wednesday, and then we'll have our exec session. I hope it goes as quickly as this one went. I'm not quite sure it will, but I'm hoping.
Well, since
and
14 and there were.
Right, we have
And there were
only 9 today. Only 9 today.
I just thought I'd mention it.
Right. And so we will. It sounds like I need to make sure of this. But it sounds like we will have a meeting on the 19th. It probably that will be the budget assistant performance audit on the Human Rights Commission will probably be the only thing on the agenda, because we've now heard and we'll have exec all our bills. So it shouldn't be long. We'll probably start at 10 and,
But
Oh.
and you will each get a copy of the audit.
Right.
This is it. And
Make sure you have a glass of wine with you before you start
Well,
reading it.
It is really tough reading, very tough reading, and this was all transpired at the request of the Judiciary Committee.
Could I have mine? I read mine, or any chance of that?
All right, do we have any, yes, Representative Manos?
Mr. Chair, I believe you mentioned there were 2 performance audits, and I thought you had said that, and I was just wondering if you could clarify what the other one is, if there isn't.
Oh, no, I'm sorry. I think the only one that I missed, no, it's just,
They're performance audits all the time, and they're excellent, but for this committee,
I think it's just, this is the only one, right. All right. Right. All right, any other business? All right, I think we're adjourned, and thank you to our substitutes for your being here. Appreciate it very much.
Thank you very much.
All right.
But as to the performance audits that were adjourned, I would say to you, I hope that reading this, you will get caught up in their value, and from now on, each time that another one is produced, that you read it, because the quality of the work is superb, and it really helps to inform what we're doing here.
All right. Thanks, everybody.